what is the purpose of justice? To ensure that the person who has committed an offense or any kind of wrong should be punished. At the same time, the one who has not done anything should not be punished. What is the purpose of law? To ensure that whoever has committed crime or any wrong should be reached to the level of punishment, and whoever has got victimized should get justice. Now these are the purpose. Let's take one illustration. Imagine you are walking in a park and suddenly you see two brothers running inside the park. You know them, you know that they are the brothers, and one is running to save his life whereas the other one has gun in his hand who was chasing the other one. Now they both come to the dead end of the park and then they jump the compound. After they jump the compound, you hear their conversation. The one says, "We are brothers, please don't shoot at me." The immediate second after that, you hear a gunshot. Now you know that what exactly has happened, but you are not an eyewitness. Yes, it is a circumstantial evidence, but then you have not seen this complete scene by your eyes. You are present there, many people have seen that also, and now you are coming to the court and giving an evidence that this is what happened. Now whatever you have heard is heard, you have not seen it. It is a kind of hearsay. Now can court accept such kind of witness? Hey guys, welcome to my legal classes. This is Ganesh Pujari, and the introduction for section 6 has gone quite lengthy, which is all about res gestae. The section 6 in Indian Evidence Act says relevance of facts forming part of same transaction, and the literal meaning of that is res gestae. It is not exactly used in the Indian Evidence Act, but this is the right term that we can use for section 6. With that, I am taking you to the first slide where we will understand the meaning of res gestae, and as always I have tried to make it very comprehensive with lot of aspects including beautiful different case laws and other stuff. Why to waste time? Let's get into the first slide. First thing first, let us try understand the term meaning. Res gestae is a Latin term which means the things done. Now remember, hearsay evidence is not accepted as an evidence, which is very clearly mentioned in section 60 of Indian Evidence Act, but the exception for that is the rule of res gestae, which is primarily discussed in section 6, but then it has continued to few other sections also, which I have explained in my next slide. Now it is an exception to hearsay. That means here you are not an eyewitness, but if there was any statement which is made naturally, spontaneously, or without any deliberation during the course of an event, carry high grade of credibility, and thus court believes them to be true. Now there is a transaction happening. The transaction may be a crime or contract or something else. Now while that is happening, though you have not seen something as an eyewitness, but there are certain evidences coming which are coming in the form of statement which are made naturally, spontaneously, or without any deliberation. Now you have no time to plan and do something, but it is coming very naturally or spontaneously or without any deliberation, and as they have come very naturally or spontaneously or without any deliberation, or as there was no space for anything extra to be done, the same can be considered as the things done or the res gestae. Let us try understand the concept with the help of an illustration. Imagine there is one Mr. A and one Mrs. B who are husband and wife. One day, husband was beating his wife outside the home, and after some time they got inside the home and wife cried loudly that "Don't kill me, don't kill me." X, Y and Z were the bystanders who heard the statement of B, and they have also seen what exactly happened outside the home. Now after B crying that don't kill me, after some time there was all silence, and when they gone inside the home, they saw the dead body of B. Now whatever X, Y and Z as bystanders have seen earlier and heard later. Now, whatever they have heard, it cannot be an issue because in the murder they are not eyewitnesses, but it can become a fact in the issue and it becomes the relevant fact. Now, as it is the part of a fact that there was a beating and then a statement and then murder, so as they have witnessed that by hearing it, though they are not eyewitnesses, though they are bystanders, their statement will be considered as a relevant fact under the rule of Res Gestae. To understand more, let's get into the next slide where I am discussing section 6. Section 6, one of the easiest section, and remember when it comes to the Evidence Act, this act is mostly common to many of the countries in this world, and even the section like section 6, if you refer few of the other countries, the section is as is. That way, by understanding this particular act, you are almost learning Evidence Act of many countries, but the name will be like for India, we are using Indian Evidence Act. For others, maybe they are adding their name and using it. Now, what does section 6 says? It says facts which, though not in issue, are so connected with the fact in issue as to form part of the same transaction are relevant whether they occurred at the same time and place or at different times and places. To understand this section, I have made a simple chart. Now imagine there is a murder as we discussed in our previous illustration. The husband has murdered his wife and XYZ have heard the statement of wife, that is, don't kill me. Now in murder, that particular statement is not an issue because here issue is murder. But one of the facts that we have to prove is husband had the intention to murder his wife. Okay, now that way the statement becomes the part of one of the fact, that is the intention to murder his wife. So the statement is not part of murder, but it is proving the intention of murder. By that it becomes the part of one of the fact in the issue. So when that happens, it is called Res Gestae. The same can happen in two possibilities, one in the same time and place, the other one different times and different places. Now the simple illustration for same time and place is, if you are hearing the sound of a bullet, you are hearing in that place at that particular time, so that becomes the example for same time and place. Likewise, statement or cry of an injured person or cry of the witness who see the murder happening or the cry for help by a person who got attacked or gestures of dying person. All of these are happening in the same time and same place. Now that's quite easy, but there are opportunities to happen in different times and different places. For that I am explaining the case law of Hamsa Kunja versus Regina. Now here in this case law, there was a worker by name A who was beating another worker inside the factory. Now B saw and said to A that that particular worker is very weak, don't hit him. But A continues and says that if you would like to join, you can also come here, I will beat you also. At this point, B says that he will report the incident to union and A threats B that he will take care of the same. Now, many other workers in the factory have heard the conversation which happened between A and B. On the same day evening, somewhere outside the factory, A beats B. Now, the first incident has happened in the morning inside factory. The second incident has happened outside factory in the evening. Now, there is change of both time as well as place, but now when the people who have heard the conversation between A and B in the morning inside the factory will give witness, and that witness is acceptable under the concept of res gestae, or that witness is relevant under the concept of res gestae. I hope that is very clear. Now, there is one word used in the definition, that is transaction. I have given in the meaning box, yellow box, what is the meaning of transaction. It can be a crime, it can be a contract, it can be an error, or it can be anything of other subject which are part of inquiry. Now, these are the things you can remember as far as transaction is concerned. But whenever res gestae topics comes to discussion, most of the time we take the help of murder, because in murders this is being used lot of time. Now, section 6 deals with res gestae as a general term, whereas section 7 to 17 are dealing with res gestae with specific terms that we are going to learn in future. For now, I am taking you to few important tests we have to do with res gestae in my next slide. There are many tests that we are discussing when we are discussing about res gestae, and I have tried to bring few of them in one simple chart. The first one I am discussing about test of applicability of the evidences which are given under the concept of res gestae. There the test will be on the proximity of time, proximity of place, continuity of actions, and community of purpose. When all of them are coming together as a beautiful relevant fact, then the same will be applicable as a worth evidence or valid evidence. The second one is test of admission. It is always discussed, was it spontaneous evidence, or was it a relevant identification, or was there an opportunity for error, or was there any concussion opportunity. That means you can make it like your own story, something that should not happen. Now, if it is spontaneous, excellent, and there should be relevant identification and there should not be any opportunity for error. Now, if something has happened in dusk based on height, etc., if you are guessing it to be someone else, that is not okay. Now, you have to very clearly say that it was so and so person, and it was so and so person shouted, and the other one has committed. Now, that needs to be very clear. Even if it is dying declare, the declaration should be very clear. Only then the same will be admitted. The third part is 3 tests of res gestae, where we will see cause and effect test, time and place test, and continuity of purpose and action test. Cause and effect, there should be purpose and then there should be result. Then time and place, there I have told 2 different aspects, same time and same place, or different time and different place. I will again try discuss one more case law for this. And then continuity of purpose and action. Now, when a wife shouts that don't kill me, there we can see husband's mens rea of having an intention to kill her, and then he proves it by murdering her. Now, that is continuity of purpose and action. These are the important aspects that you need to remember, and you can fix them anywhere in your answer as per your wish. Here are the 4 illustrations which are given under Act. I am not going to discuss them because I have already discussed 2 illustrations and I have many case laws coming forward. So we will understand the concept in those case laws itself. This is a screenshot slide. If you want to take a screenshot and read, you can read them. They are very easy, which are discussing about the res gestae being relevant fact for every single case law. I am moving to case laws, which I have divided into 2 different categories. One, the important case laws, and then the important case laws as far as Indian circumstances is concerned. Why to waste time? Let's get into the case laws. When it comes to important case laws, the first timeline that I am bringing here is the 1693, which is also considered as one of the earliest case law as far as res gestae is concerned, which is Thompson versus Travanin. Here it was held that declaration accompanying an act as evidence is receivable. Now that is what held, but remember this as the first case law for the res gestae concept. But if you ask what is the most important case law on res gestae, then you can refer the 1805 case law, that is Avison versus Lord Kinnaird. From that case law, lot of other case laws started considering res gestae as an important concept. But one of the most infamous case law as far as res gestae is concerned is the 1879 case law, that is R versus Bedingfield. What happened here? Victim came out and told in front of the witness, "Oh aunt, see what Bedingfield has done to me." Now she shouted that and she did. Now, in this case law, the statement made by the wife with her aunt was not accepted as a valid thing because she was not shouted while actually her throat was slit. When she came out, the throat was already been slit, so it cannot be considered as an evidence. Now, if you ask me, the later judgment considered that as a failure of justice, and then it started considering even the just earlier incidents, the actual incident, as well as the immediate later transactions, all of them as part of res gestae. Such widening the scope of res gestae has happened in the case law of Ratton versus R. We are considering this case law as an overruling judgment to R versus Bedingfield also, and this is famous because this has actually widened the scope of res gestae by giving importance to the events which has happened earlier to the actual incident or later to the actual incident also. Earlier in R versus Bedingfield, only the events which happened during actual crime was considered, but here the meaning got widened. Now Ratton versus R I am going to discuss when I am discussing the next important point, that is different times and different places. We have already understood the case law of Hamsa Kunja versus Regina in my last slide, where we have discussed the term different times and places, and one another beautiful case law for this is Ratton versus R. Here, husband was an accused of murder of his wife, and husband says, "That day I was cleaning my gun and I never had any intention of killing my wife, but due to misfire in the gun, my wife died." Now, there was no evidence to rebut his statement. But then comes a beautiful evidence in the form of a telephone operator who says, "Just before this incident has happened, I got a telephone call from this particular lady who said, 'Get me the police, please.' And while she was requesting that, she was sobbing and she requested in a hysterical state." That means there was something wrong which was happening in that particular home, and later to that, husband has killed his wife, which means he had intention of killing his wife while she called. Now that was considered as a relevant fact to the fact, and then the accused got convicted. That is an example for different times and different places. Now let's move on to Indian cases. The first case law here is Uttam Singh versus State of Madhya Pradesh, where a father and child was sleeping together and a person came and slit the throat of the father. Immediately, child saw the accused and shouted his name, and after hearing the cry of child, all the family members came and they heard the name which shouted by child, and the evidence of family was considered as the relevant fact to the case based on the theory of res gestae. The second case law is Bhishna versus State of West Bengal, where two brothers were attacked by few people and one got killed and the other one got seriously injured and almost in unconscious stage, and all this incident was witnessed by the mother. Then comes the other witnesses who heard the entire story from mother and the other one who was almost into unconscious stage, and then they give the entire statement in the FIR. Now whatever is being told by the witnesses who heard by the mother is also considered as relevant fact because they have reached the place immediately and there was no time for them also to change any of the fact. that way that was also considered as relevant fact under the theory of Res Gestae. The third case law, that is Savaldas versus State, where there was a fight between husband and wife for the matter of dowry, and then husband killed wife, and before she died she cried bachao bachao, which was heard by the children as well as bystanders. Now the evidence given by the children as well as bystanders are considered as relevant fact under the theory of Res Gestae, because whatever wife has shouted, that was a spontaneous cry from the person who was dying. So this is part of Res Gestae and this was considered as a valid evidence. Yes, as I have already told in section 6, the term transaction includes any kind of crime or contract or any issues or the things which are discussed under inquiry, etc. However, the most of the time this particular principle is applied during murder cases, and in rape and domestic violence such evidences may come little late also, considering the Indian scenario where our culture is different. When someone gets raped, they may not immediately come to police station, they might think and come. In such times the Res Gestae theory is not very rigid that it has come little late. However, it comes early, it is excellent. It comes late, then there is the possibility of proving and disproving, because there is chance for concussion. So that way Res Gestae is always good when it comes as quickly as possible. It should be spontaneous. There should not be any time for planning anything. When that happens, this stands as a very important aspect. But then if you are investing more and more time, then it loses all its importance. That is what you need to remember. That's all for now. But remember, if you are thinking this is too lengthy presentation, I am telling you guys, this is with lot of difficulties I have reduced to this size. This is a very lengthy topic. We can keep discussing on this hours and hours. But for the educational purpose, this is sufficient. So that way I have structured this particular video. And remember, this always goes on case to case basis. So if you are practicing advocate, then you need to be very cautious about the Res Gestae concept. While you are putting in your first statement itself, you need to cover all of them very cleverly. Otherwise, once you are delaying it, it loses its importance also. Now that way it works. With that, I'm concluding. Thank you so much for subscribing my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you're watching my channel, and thanks again.